A lot of times people call about a will because they just want to get their affairs in order. They don't want to leave their children and their wife in a mess. In the laws of most states, and definitely in Oklahoma, if you die without a will, half of your property goes to your wife, the other half goes to your children. So if you die unexpectedly and your wife has been counting on your entire estate to get her through retirement and old age, she's going to be sadly disappointed because your kids are going to take half. And so people who call to me to get wills want to make sure they're taken care of, that their spouse is taken care of, that they're taken care of if something happens to their spouse. If you don't do this, then you're going to be in court dealing with your children. Now, sometimes it's not a problem if your children are great, but remember one thing, children get married. And sometimes it's not only your children you have to worry about, it's their marriage partners, their husband or their wife. And as a result, sparks fly. So don't leave your spouse in a bad place. You should always, be prepared for unexpected events to happen in your life and get a will. You can update at any time if things change, but get your will. It doesn't cost a lot of money, but gives you a lot of peace of mind. When you need to have your estate looked at and evaluated, you need to select an attorney who has life experiences. In our society, more than ever now, we have blended families. We have children from two different sets of parents, sometimes three. And as a result, it's very complicated to take care of all your children, take care of a spouse that you currently have that means a lot to you. Not many people have the personal experience of a blended family. So there's a lot of emotional and spiritual problems you have to navigate. So you need to choose someone to do your estate plan who has real life experiences, who understands that, who can talk to your spouse and reassure them this is going to be in the best interest of both of you. You're taking care of all the children, just not one set of children. Jealousy with children become a big factor. Envious of other brothers and sisters from the other spouse is a problem. Somehow you have to navigate this and put everyone's with peace. The last thing you want is for you to pass away and have nothing but turmoil and litigation over your estate because of something you said or didn't say. The best thing you can do is prepare, execute the appropriate documents, and do a couple of videos to all the children telling them this is why you're doing it, this is what you want them to do and think, and this is how you want them to act and treat the surviving spouse. It's hard to go against that if you hear it from your father or from your mother. And so you need a lawyer who understands these things. I call it, make sure you get your ducks in a row. The last thing you want to have is have a problem in your life, you become incapacitated, you pass away, and your ducks are not in a row, and you leave nothing but pandemonium and disaster for your heirs. The biggest problem people make is not doing it. Any plan's better than no plan. I think once you have a plan, you need to revisit it regularly. I always told my sons, you're in my will and my trust as long as you're not a knucklehead. If you become a knucklehead, then I'm going to change that. The other thing I think that mistake people make is that they think that that the heirs will have the same feelings about what they've accumulated as they do. They think that their children's spouse will feel the same way about the things they have as their children do. They don't. The biggest problem, I think, in estate planning is that when you pass away and you have a division of the assets as per the trust or will, then sometimes you might put a valued piece of family property in the hands of a son or a daughter, and they put it in the name of both themselves and their spouse, and then there's a divorce, and then your family might not end up with a piece of property. So you have to really look at all the problems that may happen as you pass away and you pass to the next generation your estate and your heritage and your legacy. Sometimes it's good to leave things in trust and not put them in the name of any one child. That way you can ensure that your grandchildren, great-grandchildren will have something there that won't be decimated by a divorce or sold because of property settlement or resolution of a divorce. I tell a lot of people when they come to me about estate planning that doing a will and an estate plan is a little more expensive than just a plain will. But when you do a trust and a durable power of attorney and a healthcare directive, you're kind of prepaying your estate, your probate. When you have a trust, you don't have to probate your estate because your assets are owned by the trust. The trustee takes over upon your death and you don't skip a beat. Your heirs don't skip a beat. When you have a will, everything is kind of frozen for 69 days until you can get a personal representative appointed. And you have to oftentimes file an inventory of your estate, and all your assets are a public record then. So everything you've accumulated, you have to file with the court, and so people can see what you have. And a lot of people don't like that. They want to keep their assets a secret. So sometimes paying for a trust to be done is a bargain. It's not as expensive as people think, but I promise you, once you do it and you have your ducks in a row, the peace of mind will be worth the money you spend. If you don't do it, then you'll spend a lot more in a probate than you anticipate. A lot of people say, well, whatever my kids get, it's more than I had, so I'm not going to do a probate, I'm not going to do a will. But what they don't know is if they could see what happens without those instruments in place, they have a lot of buyer's regret by not doing it.